94 trial courts in the U.S. and one federal court. I'm sorry, in one bankruptcy court in each district, and then also a U.S. Court of International Trade, which regulates any export, imports, cases where an importer or an exporter would get sued by another country or within our own country, and also any federal claims from federal employees or any federal suits where the federal government would be sued by an individual or a company. So just that's kind of where the first step, the court of origin is in the trial court. So that's where Koch and Nash took their case. And what they did was so the case can be civil, criminal, bankruptcy, as I mentioned, and they're for violations of federal law or the Constitution or their bankruptcy hearings. So these aren't like a speeding ticket you wouldn't go to federal court on. And what they asked for is declaratory relief, which they were asking for a binding adjudication that established the rights and other legal relations of the parties without providing for or ordering enforcement. So they were kind of asking the court to just decide. I think that they knew all along this was going to go to the Supreme Court, so they were just asking to come up with a decision, and so they can move on. And then they were asking for injunctive relief, which for them meant that they didn't want the state to be able to say no to their permits or licenses, so they just wanted the court to put a hold on them and say, okay, we'll hold until we get a different decision, through the courts. But what ended up happening is the district court actually dismissed the defendant's case or their complaint altogether. So their next option was to go to the U.S. Court of Appeals. So in the U.S. Court of Appeals, it's pretty much, you go from the district court, you don't like their decision. It's kind of like going to mom. Well, now I'm going to go to dad and ask if I have a cookie because mom said no, I can't have a cookie. So they went to the appeals court, and which there's 12 of those in the country, with one for the federal circuit also, and they were established by Congress because in the beginning there was only the Supreme Court, which heard all the appeals, and it just became a long and arduous process for the Supreme Court justices, and there was as the country grew, there's way too many cases for them to hear, so the caseload got enormous, and they actually started the appeals, U.S. Circuit Court of Appeals, and there's 12 of those. So they get the court cases from the district courts in the appeals court. So Bruen case went up to the appeals court, and they affirmed, which means that they agreed with the decision of the district court to dismiss the complaint. And what they relied on was the Second Court of Appeals prior decision, or in other words, precedent, in a case called Kachelski v. County of Westchester in New York, which said that the New York licensing requirements actually were substantially, and I'll quote from the slide, but substantially related to the achievement of an important governmental interest. So they pretty much held that, yes, the government has a substantial interest, and if anybody knows New York, they really, they're pretty stringent on their gun ownership and gun carrying. So they said yes, because of the potential for harm to the public, we hold that we need to know everything about you, and that you need to have a license to carry and not just, carry it openly or what have you, like a lot of states have. So because that they held and affirmed that decision, it now Koch and Nash, they actually went to the big daddy of them all, the Supreme Court, and they asked the Supreme Court the same questions. They wanted to know, okay, well, we think that the New York State is going a little far, and we want to be able to carry a gun just based on self-defense, and we don't need to show that we're in constant danger for our lives, that to be able to carry a firearm as stated in the Second Amendment and already upheld by the Supreme Court. So the Supreme Court is in Washington, D.C. It's the highest court in the nation. Cases can go up to the Supreme Court and they can remand them back down, but appeals, if it does go back down to an appeals court or back to the circuit court, they can't disagree with the Supreme Court and say, okay, well, we don't agree with you, so we're going to overturn your decision, Supreme Court. That can't happen. So, the Supreme Court can hear cases involving state v. state. They interpret the language of federal law and the Constitution. They'll deal with civil rights cases based on the Constitution, and they also hear treaties. When the Congress gets together and then signed by the president, we have a treaty, and this might be some language that, or even with another country, there might be some language the Supreme Court can come in and say, okay, well, that's not constitutional, so that, you need to tidy up the language, and then they go from there. So back to the Bruen case, the defendants filed a writ of certiorari asking the Supreme Court to take up the case, which the Supreme Court said, yes, this is an important enough case. They take less than 100 cases a year, and out of, I believe, 8 or 10,000 cases that are sent to them, and they said, yep, this is an important enough case. We should hear it because it's in the best interest of the country. There are a lot of gun owners in the country, so I think a lot of like the NRA or the National Rifle Association and a lot of other lobbyists were waiting for this decision to come down because they wanted to know what was going to happen and where the Supreme Court was going to land on this. So the Supreme Court held, or in other words, they ruled that the conclusion was binding on both parties, and now the law of the land, which was you have the right to carry because New York's proper cause requirement violated the 14th Amendment by preventing the Nash and Koch from carrying, and they said that you should be able to carry just based on ordinary self-defense needs, and it's your Second Amendment right to bear arms in public for self-defense. So they said, we're gonna rule that this case is in favor of the plaintiffs, with the defendants being the state of New York and the designees. They said, you're able to carry in public with a license. States have the right. I think there's 6 states that actually have the right to. You can't just carry openly on your hip with the gun just showing out to everybody. There's about 6 states that say you need a license to be able to even carry openly like that. New York being one, Massachusetts being one, California being one. Surprisingly, Florida was one to me. But now a lot of states are going to have to go back and rewrite their laws. But what they're also doing is now they are saying, okay, well, that's great. Yep, you can get a license to carry for self-defense. However, the states can make the Supreme Court decision or a federal law more restrictive. So now they're saying, okay, well, you can't carry in Central Park, or you can't carry in Manhattan, or Times Square. You can't carry in certain places even though those are some of the more dangerous places in the state. But now they're saying, okay, well, we're going to be more restrictive. So that's pretty much our travel through the federal system through this case with the Second Amendment. Through the district to the appeals and the Supreme Court, and Bruen was a huge case. That's been a long time in the making, probably at least 100 years in the making, even though it's just kind of been coming around in the past 10 or 15 years. So thank you, and I hope you enjoyed the presentation.